Welcome to the meeting this evening. Just a bit of housekeeping. If you're not talking when you're in the chamber, can you keep your masks on? Obviously, remove them if you wish to drink or you wish to speak. It's a hybrid meeting with people joining us on Teams. Could I just ask that your camera's turned off if you're not speaking and turn your camera on when you are speaking? Thank you very much. Okay, the first item this evening is any apologies?
None received, Chairman.
Okay, thank you very much. Is everybody who should be here at the moment?
We're just missing Roy Van Pelt.
Okay. Okay, he may turn up later, sorry. Okay, minutes of the previous meeting. I assume everybody's seen a copy of the minutes of the previous meeting. Does anybody have any comment? Yes, should be here.
Hi, thank you. I had a question. It's actually about a point that I raised. I think part of it was missed. That it's relating to the section where I said there's clarification of the definition of the co-opted member in the social media guidance. One part of that, first part of that I raised was actually there are 3 definitions across our various bits of paperwork, including I think it was the Localism Act, the social media guidance and the code of conduct, and they disagree with each other in that the inconsistency implies in one case that they should have voting rights and in one case that we don't, which is obviously how it is. I did give the three printout of the 3 places that had appeared to Neil, but that wasn't minuted. So I wonder if that could please be added.
Okay, is everybody happy that I add that to the minutes? Okay, yeah, that can be added to the minute. Thank you very much. Thank you, Sally.
Thank
you. Okay, declarations of interest. I don't believe we're talking about the company, so not necessarily. Anybody else got any other declaration of interest? Yes, we've all got some sort of interest, but okay. Number 4, public question time. Have we any questions from the public? Thank you very much. Parish / town council question time. Okay. And no member questions. Okay, doesn't say. Well, I see. I missed that. Sorry. Okay, so we go to item 7, which is an update on the member code of conduct, which is set out in page 11 to 13. I believe you are presenting this. Is that correct, Andrew?
Yes, Chairman, if I could introduce this report to members. Good evening, members. So you'll recall at our last meeting, we talked about the new code of conduct code that the council adopted shortly after the last standards committee meeting, and we also talked about different views that members of the committee had about the process for handling complaints. And you asked for an independent expert view in terms of how our process compared with other local authorities. So we've commissioned the said independent expert, who I'll introduce in a second, Paul Hoey from Paul Hoey Associates, and Paul will introduce himself in terms of his very extensive background in this area and working with possibly pretty much every council in the land around standards matters. So Paul's very experienced. You'll see in your pack from page 9 my covering report, and then Paul's analysis of the council's current processes. So just in terms of headlines, the main headline is, and I quote the report from Paul Hoey, it says the Wokingham process is broadly in line with the processes in most authorities and represents good practice in many aspects. So in terms of the overall sort of conclusion, I think you can take a fair amount of assurance from that. However, within the report itself, there are 9 areas that are identified for improvement. And I just wanted to flag up, just by means of introduction, 3 of those areas. So firstly, and this is an issue that I know the committee has looked at for some time now, and this is the particular issue around the non-disclosure of a subject member's name who has been found to have been in breach of the code of conduct, but the complaint was settled using the so-called informal route. So I'm sure Paul will talk about that. And then there were two other areas in particular that I just wanted to flag up. Firstly, around how hearings panel processes are run, and Paul will explain that. And if you've got any questions around that in particular, Jennifer Lee, who's on the call this evening, will be able to respond to those. And then thirdly, the issue around the monitoring officer's consultation with the chairman of the standards committee in the earlier stages of the process. That's one area that Paul is recommending that we look at differently. So just before I hand over to Paul, with your permission, Chairman, just to look at the recommendations in front of you for this report. So it is to look through the 9 areas of recommendations that are being made this evening. Should you accept those, then the process would be to take those forward to the Constitutional Review Working Group and then on to Council. I would hope that we could do that for the November Council for those 9 areas that you approved tonight to go forward in that process. And secondly, the recommendation to delegate to myself in consultation with the chairman the detailed drafting of the changes around those 9 areas, or whichever areas you agree to be taken forward, to give that delegation to myself just to make business, as opposed to having to bring back those proposed changes to the constitutional wording to a future meeting of the Standards Committee. That's really all I just wanted to say by means of introduction. But as I say, Chairman, with your permission, if I could ask Paul to introduce his report, and then between myself and Paul, we'll take any questions that the committee may have.
Yes, that's fine. Paul?
Yeah, hopefully you can see and hear me from the miracles of technology, speaking to you from West Yorkshire. So greetings to everyone in Wokingham.
Thank you.
Yeah, just to introduce myself formally. Yes, my name is Paul Hoey. I'm one half of a company called Hoey Ainscough Associates, which I run with my colleague Natalie Ainscough, who sends her apologies tonight. She's got an unavoidable domestic commitment. So you've just got me tonight, I'm afraid. Just to explain my background and who I am after those very warm and gushing words from Andrew. For those of you old enough to know, old enough to remember, which is probably fewer and fewer people these days, but I used to work at the Standards Board for England, which was the national regulator in 2012. I was director of strategy there. Essentially, that was the national regulator which oversaw the National Code of Conduct. And when the Standards Board was abolished, Natalie and I set ourselves up as a private company, supporting councils on all sorts of code of conduct standards related issues. So as Andrew says, we've worked with around 400, 500 councils on Localism Act arrangements. And of most relevance to this evening's discussion, I guess, we were the local government advisors to the Committee on Standards in Public Life when they did their review of the Localism Act arrangements in 2019. And we were also commissioned last year by the Local Government Association to draw up the new model code of conduct and associated guidance that goes alongside it. So that's who we are. When we were asked by Andrew to do the review, we really saw sort of a number of parts to it. Clearly, the review we've done is a review on paper, so looking through the process as it's written down. We've said very clearly to Andrew, of course, you know, just because you've got a process written down doesn't necessarily mean to say that it's absolutely, you know, followed to the letter. So we did discuss with Andrew as well that if members have concerns to say they don't think this process is, you know, even if the process is good, whether they've got concerns about the way it's being followed, we did say to Andrew we would look at some sample anonymized cases to see if the process had been followed correctly, and that we will talk to Andrew separately about doing that if it's needed. And the third thing was we were commissioned by the Local Government Association to produce a piece of guidance on good practice around case handling. That was only published right at the end of September. So what is in the report reflects a lot that's in the LGA guidance, but we will, you know, again, re-benchmark it after this discussion, because there are some very, very minor points which we might want to pick up outside of this meeting with Andrew, which are broadly technical draftings. So that's how we went about doing it. As Andrew said, our high-level finding is that your process is in line with what we see elsewhere. The Localism Act obviously just says your council must make arrangements and doesn't specify what those arrangements are. But nearly everywhere we work has very similar arrangements, where much of it is delegated to the monitoring officer in consultation with the independent person. And then as the process goes through, the hearings panel gets involved towards the end. And there are various points where you're seeking informal resolution, as we would expect, because we want to keep the framework relatively light touch. So that's our broad conclusion. And as Andrew says, there are some minor tweaks that we were suggesting, some key areas which Andrew has touched upon again. The role of the chair in working with the monitoring officer, particularly at the start of the process, issues around whether hearings should be held in public or private, and this issue around whether somebody who's been found in the breach of the code of conduct, but the matter is resolved amicably, how far they retain anonymity, etc. So those were the key areas, and I'm very happy to take any questions, elucidate on any of those points further if you wish.
Yes, Prue.
Oops, I have a sort of a technical question before we discuss the points, which is on your point 11 on page 13. This is about the time scale that should be given to, oh, I'm not speaking loud enough.
I can hear you, don't worry.
Okay. The time scale which the subject member should
Yeah.
provide comments. You haven't indicated a time scale in there, and I was wondering what time scale you would suggest.
We would normally suggest 10 working days. But obviously, with the ability, if the subject member's away on holiday or is what have you, that there is scope. But we would say 10 working days seems a reasonable time to turn those things around.
Imogen.
I'd just like to clarify, I'm presuming that these recommendations also apply to towns and parishes as well as the borough.
Yes, just to be clear, the Localism Act says that where it's a complaint against a town or parish council, then the borough council handles it. So all these arrangements would be the same for a town or parish council complaint. Obviously, there is the issue about for a town or parish council complaint, the clerk is consulted by the monitoring officer, which is obviously wouldn't happen at the borough council complaint.
Do I see any more questions? Okay, I'd just like to ask a question, really. We have these recommendations, Andrew. My question is quite simple, really. It's some of them involve you in additional work. Some of them involve the way that you work changing. I mean, what are you suggesting as your recommendation as a monitoring officer, as the linchpin in this whole?
Yeah, well, my position would be I would support all the 9 suggestions or recommendations that are made in Paul's report. I think, as we've talked about with the committee over the past few meetings, we have had backlogs, and we've rehearsed some of the reasons for those backlogs. But I think certainly some of the suggestions that are made in Paul's report would help to give some focus and to help us turn around certainly minor complaints more quickly. I think, yeah, I'd be very supportive of all 9 recommendations that are in the report, Chairman.
Okay, I mean, does anybody want to go through the report in the meeting or talk about some of the changes? Because some of the changes are obviously fundamental. I mean, would you like to just run through what you think are the major changes that will affect members and public's view of what we're doing?
Should we just take each of them briefly then, just to be clear what members are agreeing to this evening then? So if I just turn to Paul's report. So we start off with on page just bear with me, page 13. So this is purely about, on paragraph 7, purely about publishing, making the process more visible to the public. I think that's pretty self-evident, very easy for us to do. That may help in terms of transparency. I'll pause, Chairman, if there's any questions at all, but if not, I'll just crack on with the next one. So 9.
I got a question about that. What you're saying, the public involvement is in these meetings. You're talking about a formal investigation, are you? Or
no,
I'm not clear.
This is solely, Chairman, to make the process for handling complaints very transparent to the public and particularly to complainants. It is there in the council's constitution at the moment, but it's not perhaps as visible and easy to find as it could be. So I think, and correct me if I'm wrong, Paul, but I think this is really just about making it more visible and transparent for people.
It is really. It's just about putting another link in. So you've got a very short summary about how to make a complaint on the website, but then it doesn't really link to the greater detail in the constitution about how your complaint is handled. So we're just suggesting almost that there is just a link there. So if people want further details, they know where to go.
So you're talking about communication link,
Yes,
basically,
yeah.
on the system, right? Okay, yeah, I've got no problem with that. Anybody else got any problem? No, nobody. Everybody's shaking their head. They got no problem. Go on, carry on, Ian.
Okay, paragraph 9. So this is right at the beginning. So the acknowledgement of the complaint, there's nothing actually set out in terms of the timescale for that, but certainly the custom and practice has been to do that pretty immediately, certainly within 3 working days. So that is just a recommendation to formalise that and to make it clear to complainants that they will expect to hear from me within those 3 working days.
Okay. Yeah. Any question? No questions. Oh, sorry, Imogen.
Hello, Andrew. What happens when you're on holiday?
I've got a deputy in Jennifer, who's on the call tonight. So we would make sure that there's cover.
Okay, thank you. Carry on, Andrew.
Okay, paragraph 11. So this is the point that Prue asked the question about. So timescales from the subject member, i.e. the member who's the subject of the complaint. I think, Paul, you said 10 working days.
Indeed.
So again, at the moment, this is perhaps sometimes in terms of what happens at the moment where we lose time on complaints, and that there sometimes is something of a backwards and forwards between myself and the subject member, particularly if sort of new information or additional information is introduced. That can prolong the initial process. So paragraph 11 seems a sensible way to give some focus to that early stage.
Yeah, I'm very keen on that, but does everybody think 10 days? Sorry, Prue.
I was just going to say, provided that when you word the constitutional change, it allows for the fact that somebody can be on holiday and is unable to respond within the time period. So I don't want a kind of endless lot of extensions or something, but I think 10 working days is the norm, and an exemption can be provided if circumstances require it or something like that. Yep.
Okay.
Yes, yeah, we give the power to the monitoring officer that he can extend that period if he thinks it's reasonable, if somebody's in hospital or something like that. So I think that does need to be written into that you have the power to extend that if you feel that there's a need to do that. Everybody, sorry, Sally.
If I'm on holiday and you contact me to tell me that there's a complaint against me, I'm not going to get that for 2 weeks because I'm on holiday. So could we maybe not make it 10 days, maybe make it 15?
Well, I was thinking about 15. My problem with this is that the main reason for doing this is obviously to stop people just dragging it out and we get the blame because it takes a year to do something. But I'm happy with 15 if everybody else is happy with 15. 15 days? Yep. Yeah, 15, Andrew. And
Okay.
with the proviso that you have the ability to flex that in in circumstances that require it. So somebody in hospital or something like that.
Sure.
Everybody happy with that? Yeah, okay. Go on, Andrew.
Okay, paragraph 13. So this is specifically with regard to complaints about a town or parish councillor, where the constitution requires me to seek the clerk's views on the complaint. But as Paul highlights, it's not entirely clear what the clerk is being asked to comment on. So this is just a housekeeping, tidying up suggestion to make it clearer that we're really seeking the clerk's view on factual matters, not giving an opinion on the complaint or the councillor concerned. I think 13 really speaks for itself and really is just a tidying up clarification point.
Yeah, Prue's got a question.
Yeah, I do. I should have thought this before. What happens if it's the clerk that's brought the complaint against the councillor? Does that situation still apply?
That is a good point. I don't know, Paul, whether you'd like to comment on that.
Do you want me to answer that? I think that's part of the reason we're really asking just for factual comments. So, for example, if a complaint comes in that a councillor has failed to declare an interest at a meeting, it's perfectly appropriate to ask the clerk, even if the clerk has made the complaint, could you send me the minutes to demonstrate that the councillor was actually present at the meeting at the time, rather than absent? Whereas if you get a complaint saying that the subject, the subject member was bullying somebody, that's not a factual matter. That's something to be investigated, something to be looked into. You don't go back to the clerk and say, is it your opinion that this person really is a bully? So even where the clerk has complained there, you're purely trying to stick to factual evidence. And there may be times, of course, where if the clerk is involved, that you might either go to the deputy clerk or to ask the chair to correct some factual information if you think that there is such a breakdown in relationship between the clerk and the councillor. But that would be very small minority cases where you would think that the council themselves wouldn't have confidence in the clerk giving factual information.
Okay, can I break this into two parts and ask the question? Are you saying that you would formally tell the town clerk or the parish clerk that there'd been a complaint? So that would be one part of it, basically.
Yes.
So we received a complaint. Okay, so that it was very clear, and then they know. If you then needed to go to that town councillor, the parish clerk or town clerk, that would just form part of the normal investigation, and that person would become a witness. Is that what you're saying?
We're saying two things. Yes, first of all, that you would just notify the clerk there is a complaint about one of their councillors, because right. They need to know, and they read it in the local paper, they get questions, they need the heads up on that. But you may at the same time say to them, we've received a complaint about your councillor. Can you confirm that X actually attended that meeting, or that they are still a serving councillor, or what have you? But if you wanted to get into further details and the matter goes for investigation, the clerk may then become a witness. But at this stage, you would just be checking purely factual matters that Andrew wouldn't know, which would help him to make a decision as to whether or not there's anything to the complaint, it needs to be followed up, etc.
So part of the formal procedure would be the clerk would be notified.
Yes, and asked any relevant questions that needed to help Andrew make a decision as to whether or not to investigate. But it would be made very clear to the clerk whether they were just being notified or whether they were being notified and asked to clarify particular information.
So that's a formalised bit.
Yes.
Where we say the clerk will be notified that there's been. Okay. All right.
Yeah.
Is everybody comfortable with that? Yep. Okay, Andrew, carry on.
Okay, so paragraph 15 now. So in the current process that we have, the Constitution requires me to consult with both the independent person and the chairman of the Standards Committee. The recommendation that you've got in front of you tonight is that the monitoring officer should just consult with the independent person when taking that initial assessment decision and deciding on the appropriate course of action. Again, I don't know, Paul, is it helpful if you just add a little bit to that in terms of how we compare to other councils?
I think I'd say a couple of things about that. It's not mandatory for the monitoring to consult the independent person at all. It's not mandatory for the monitoring officer to do anything at this stage, because the Localism Act just says you must make arrangements. What we find with nearly every council that we work with is that the independent person is consulted at this stage, although it's not a statutory requirement. That has certainly been also made a recommendation by the Committee on Standards in Public Life, that the independent person is consulted at this stage to give that air of independence, to sort of bring a fresh pair of eyes to it. It's only a handful of councils. You're not unique, but it's a very small handful of councils where the chair of the committee is also involved in that process, and we are concerned that that might lead to a conflict further down the line when you're asked, if the matter comes to a hearing, or at least a perceived conflict. If the subject member is feeling very disgruntled, they may say, well, of course, it was your decision to investigate it in the first place when you then come to chair the hearing. And secondly, there is a concern as well that, again, if the chair represents one particular political group, then opposition groups may feel, again, that, rightly or wrongly, and I'm sure there's no evidence to support that, but that the chair may have had political views in mind when making a particular decision or recommending a particular course of action to Andrew. So we think it's much better to give the chair clean hands and not be involved at this stage.
Well, as this affects me, I've got no problem with that. If anybody else has approved.
Simply, this is something, as you know, Chair, that we've been asking for some time, because it brings us in line with most other councils and removes any possibility of anything looking peculiar. I would not suggest for a minute that you would exercise a political bias. So don't think that. It's nothing personal about you.
No, well, we've asked for we've asked for recommendation to look at what we do, and unless there's a good reason not to follow that recommendation, I'm loath to not to follow the recommendation. So is everybody comfortable with that? Okay, right, that's fine, Andrew.
Okay, paragraph 17 at the top of page 15. So again, this is just a bit of tidying up, and in practice, I can't recall a situation where this actually came into play, but as the process is currently written, if a complaint is resolved using informal resolution, the way that it's worded at the moment is that if that informal resolution wasn't successful, it suggests currently that it's unable to be pushed back to go back to investigation. So again, I think, correct me if I'm wrong, Paul, but I think what you're suggesting there is really a tidying up exercise, such that if informal resolution was unsuccessful, that the complaint could then go on to investigation.
It is, and I just wanted to add a slight gloss to that as well, which is what we're talking about is where if the subject member in effect fails to cooperate with the resolution. So if the informal resolution is that the subject member should apologise and they refuse to apologise, then we think there should be further steps taken, or the informal resolution is that the subject member needs to go on some training and doesn't undertake the training, then there should be some measure to do that. What we should have made clear is we're not talking about where the complainant doesn't cooperate. So, for example, if a member does apologise and the complainant says, "Well, I don't accept that apology," I think that wouldn't be a matter. If the members cooperated in good faith, I think that should be, you should be able to stop the process there. It is only, where the subject member themselves does not cooperate, does not participate in the informal resolution.
Okay, Imogen, you've got a question.
No, I just answered the question, which was what would constitute something that had failed, basically.
Okay, the only thing, so we are saying here then that if the person who the complaint's been made about is quite happy to rescind and apologise, even in the event that the offended against aren't happy to accept that would end there. Is that what you're saying?
Yes.
Okay, I think that's a really important point.
Yeah, provided Andrew was satisfied the apology was genuine and not, okay. Yes.
And bearing in mind, up to this point, there will be no involvement of members other than the independent panel member and the monitoring officer.
Yes.
Yeah, I'm quite happy with that. If everybody else, sorry, Sally.
Thank you. Other members of this committee in the past have raised queries around informal resolutions that are relating to complaints of things that have been said on social media. And I know that the complaints or the concerns stemmed from once something's out on social media, it's out in the wide world, and just an apology doesn't really go to redress the original. The original content is still out there in the wild because it's been put on the internet. Do we want to, or should we consider anything that is social media related or in the wild on the internet should have some kind of the apology should be in the same place or something like that? Because otherwise,
I think if we're not careful,
deal with the retractions.
Yeah, I mean, if we're not careful, we turn into a newspaper that's published a headline that's not correct, and we have to publish an apology. I don't think we've got the ability to do that, to be honest with you, unless we find somebody. I mean, as you know, we've just had a case where we felt that the spirit wasn't being followed, and we did make a recommendation, but we had no power to enforce that recommendation because we found the person had not broken the rule per se. So I think that's an extremely difficult one.
So I think that's. Sorry, I wish I'd thought of this before to this evening. I could phrase this better. Perhaps what I'm saying is maybe there should be some guidance on the informal resolution, including some kind of removal of the offending statements if they have been found. It's only relevant if they've been found in breach informally. So we should perhaps try and include something like that. And if it isn't possible to remove it, then
I'm not quite sure. If you find somebody in breach, I think you can do it. I don't.
Yeah, well, that's the only point where we're talking about it, isn't it?
No, we're not. We're saying people here that aren't that we consider them not to be in breach.
No, we're talking about informal resolutions such as apologies.
Oh, okay. All right. Sorry.
This is
Yes.
where we're relating to a breach.
Oh, right. Okay. Yes, of course. How practical is it? That's the only question I would ask. I mean, if it's on Facebook or it's on Twitter or whatever it is, proof.
My sympathies with Sally on this. I'm sure it's possible to word something in line with what was suggested about the apology being sincere, that the thing is withdrawn appropriately, or words to that effect, and you can then deal with it. And if the person refuses to remove the stuff from social media or to do it, then that will be a case where you might consider you want to go down a different route.
Yeah.
So there's a vague enough wording that you can put in there.
I'm with you. I can't get my head around how you word that, to be honest with you.
I think realistically, it doesn't necessarily need to be specifically in the wording here so much as it is in the playbook for Andrew. If that makes sense.
Andrew, you're part of your resolution, and of course, I mean, it would depend really on the person who's being apologised to. It's a point where that person's had something said about them on social media. Part of your resolution should be to get that removed from that media if possible. Okay, I know and I think the words best endeavour is probably the word we should use here. You should use your best endeavour. I don't think you can go any further than that, do you?
Well, I'm certainly happy to take that away, Chair. And just remind the committee as well what Paul said in his introduction, that the LGA has recently published further guidance, and seeing as we've got Paul with us this evening, I just wondered, Paul, whether you've got any particular comments on this area, because it is an area for all local authorities now that in terms of standards.
I mean, I think you're perfectly entitled to say, if you're looking for an informal resolution for a comment that says somebody has put on Twitter being offensive about somebody, that part of your informal resolution is that they either post on Twitter that they withdraw that remark or take it down from their feed or whatever. And I see that all the time as a fairly avid Twitter follower, people being forced to put things out to say, I've withdrawn the tweet I put yesterday. I realized that I didn't have any basis for saying that or what have you. So I think it can certainly be done. And if they refuse to do it, then that is, again, a factor that you would look at to say, well, in that case, we need to take the case to the next stage. So,
Can I just understand that? Are you saying that they should be Are we saying they must take down whatever they posted, or are we actually saying they must put an apology on there?
Well, I think that I think that would depend on the nature of what's been said, and I think that would be within Andrew's discretion to decide what's the most effective way of doing it.
Okay,
I think either of those things are possible.
okay, Caroline.
Thank you. I do have a concern at timescales, because if you're talking about complaints that are written, that can be dealt with in days. With Facebook and Twitter, it's yesterday. So I think we'd have to look at different timescales if we're looking at complaints that are on social feeds, if that's possible.
I would like to think that we could do that in a couple of days, and but I don't see that working that way. I think that part of the problem, even if you decide you're not going to, by the time you've got the apology, by the time you've got the witnesses making the comments, because Andrew wouldn't ask for an apology, I don't believe, unless you feel that there is a breach, as you point out to me earlier on. I'm not convinced that we can do it that quickly. I don't know where you feel about that, Andrew.
No, I'd agree. I don't think we can sort of have two sort of processes running, one for things that a councillor may have written on social media and one for everything else. Again, Paul, I don't know whether there's any comments you've got in terms of this particular area, other than it is a hot topic, isn't it?
It is, and the only comment I would say is that the apologies that I do tend to see on Twitter, or the withdrawals of remarks, do tend to be 5, 6, 7 days after the original tweet. I don't think anybody can realistically get that withdrawn within the hour, unless in exceptional circumstances. And that is the thing with social media. If it's on a Twitter feed, then an hour later it's number 150th on your list, isn't it? So it's not always visible.
It is a challenge. I mean, I don't know if everybody else agrees it's a challenge. I mean, it's an ideal thing to do. It would be nice if we could, if somebody said something really horrible about somebody, we could just push a button and get them to take it off. But I don't think this process allows us to do that, because especially if we are taking witness statements from people.
You could always make the complaint to Twitter and they'll delete it.
Well, yeah, but that's not our remit, is it, here, really?
But it's quicker probably than going through Andrew.
It is quicker, but again, it's not our remit. I don't know whether Twitter would want to listen to Andrew.
I mean, it is, without prolonging the conversation too much longer, but it is always sort of difficult to judge, and it is a judgment at the end of the day between what is genuinely sort of offensive and inappropriate and what is comment that the recipient might not like, but it's fair comment. So all of these cases can become quite subjective.
Yeah, well, that's the problem with all of this, isn't it? And I'm nervous about that, but I think maybe if you could take that away and do some more work on it, and Andrew, and think about how you could possibly formalise that in some sort of way and bring that back. Would everybody be happy with that? Yep. Okay. All right, Andrew, carry on.
Okay. Paragraph 19. So this is the issue about where a subject member has been found to be in breach, but it was settled through the informal route, then their name is not disclosed. So that's a very clear recommendation from Paul that we should publish the decision around a member being found to be in breach.
Okay, that's a bit more controversial. Some people will have different views about that. Prue?
Again, this is something that we have been asking for a long time. If you're in breach, you're in breach. If you're not in breach, then nobody ever needs to know because you're innocent. But if you're found guilty, it doesn't matter how you're found guilty. Your name should be published.
At least found something that you and Keith Baker have in common.
Yes, I have. It must be the only thing, but it is something we have in common.
I never thought I'd hear that. Is there anybody else got any comment on that? Yes, Daniel.
I was just wondering, is it simply that councillor so-and-so has been found in breach of the code of conduct, like a one-liner, or is there any further detail around what particular aspect of the code of conduct that would be included in that kind of declaration?
The decision notice would describe what part of the code of conduct had been breached. So it would be more than just one line.
So it wouldn't go into the reams of detail. It would just go into the fact that the council was found in breach of this rule 27.9, which states, and that would, is everybody happy with that?
I'm assuming, Chairman, that it would be the same as it would be published for somebody who'd been found through the formal route. So you get a tiny little bit in a report. It's usually 3 or 4 lines,
Yeah.
no more than that, and then a published report on the website.
Can I just add? I think it would probably say what the outcome was. So, Councillor X has, been found to have failed to treat somebody with respect and has offered an apology. So it would be the outcome in the same way as if it had gone to a hearing. It would say, and this was the sanction that was imposed.
It's something that the only question I would ask, do you think that may have an effect on somebody saying, well, I'm not going to apologise. If you're going to plaster my name all over the place, I'll fight it all the way. I want my day in court. As
I think that's always possible, Chairman. If a member felt very strongly that they hadn't breached the code, and of course that's the member's right to put their case forward.
Yeah, okay, but even if they feel they deep down inside they probably realise they have. I mean, if their name's going to get published anyway, what's the point of just apologising? Sorry, Imogen.
If they want to write a letter to the paper saying this is what happened, then that's the,
Well,
them, yeah.
we've got nothing to do really. We can't stop that, can we? Really?
no, it's up to them. But
Yeah. So I mean, I'm not adverse to this. As everybody said, if you're found guilty of doing something, the least you can expect is to have your name, even if you apologise. I mean, it might make you. What it may do, it may make people think a bit more carefully before they do or say anything. Sorry, Sally. Sorry. Anybody else got any comment on that? So this is quite a big change, and everybody's happy to recommend that change. Yeah. Okay. Yeah. Go on, Andrew. Yeah.
Okay, the final 2 recommendations then are with regard to hearings panels. So let's just put this into context. So we've had hearings panels probably approximately, if I look back in time, approximately once every 2 or 3 years. So that's the sort of frequency that we've had. What Paul is recommending is that at the moment, the way the Constitution is written, and the way that they've been transacted, there's been an assumption that they would always be held in private. And the assumption that Paul is recommending in terms of the future is that they would be open unless there were very clear reasons why they should be held in private. That's the first aspect to it, and I'll bring Paul in a second on that to elaborate. The second aspect is around the composition of the hearings panel. So our custom and practice has always been to have a politically balanced hearings panel made up of members from the Standards Committee, but that actually isn't written down in the Constitution as such. So again, that part is a sort of tidying up just to formalise the current arrangements. But if I could perhaps just ask Paul to elaborate on the question about in private or in public.
Yeah, there's two things I want to say about that, really. I mean, the first thing is that the law itself requires all local authority committees to meet in public unless there is a specific reason that the information being considered is confidential or exempt, and that has to be looked at on a case-by-case basis. So you can't give a blanket confidentiality exemption to a whole committee. It has to be looked at every meeting. So the first thing is that you can't have in your constitution it will meet in private, because that is making presumptions which can't be followed through and aren't lawful. And the second thing, and it also goes back to this point really around publishing the name of people who've breached the code of conduct, even when there's been informal resolution. The government policy very strongly is that they removed the sanctions from the previous regime of the Standards Board, where there were powers to suspend and disqualify councillors, because they felt that the only way councillors should be removed from office was essentially through the ballot box, through the electorate. But the electorate can only do that if they have information that there's been a breach of the code of conduct, or indeed that there hasn't been a breach of the code of conduct, and that relies therefore on things being seen transparently in public to allow the public to make their judgment when it comes to the ballot box. And that's certainly the government theory, which again is why it's government policy for hearings to be held in public unless there's an overwhelming public interest that there is a specific piece of confidential or exempt information being discussed. And again, that's in line with the Local Government Association guidance recently published.
Okay, any questions? Prue?
I don't have a sort of question. I think I probably know the answer. So this is the same rules that govern all the exemptions and all the other information. But would, for example, something that would allow you to have it in private if the person was accused of saying, leaking confidential information about the council, and you didn't want that information to be leaked any further, so you could hold that bit of the hearing in private where you discussed what the content of the information was that had been that was associated with that kind of thing?
Yes, yeah. Absolutely. It'd be the same rules as would apply to any committee. So, you know, if there is information which is specifically confidential or exempt information in line with probably what you call part 2 information, then that would be, you could hold that in confidential session, but you would have to make that decision at the hearing.
But not but not to project, not just because the person was embarrassed that they were going to be mentioned. And no,
there has to be a specific legal reason. Yeah.
Sally.
How does that marry up with the fact that anybody who currently has a complaint against them is effectively confidential information that not even we have?
Well, I was going to get up that in a moment. Can you just hold that?
Sure.
Imogen.
I was sort of questioning what happens if it was a safeguarding point. If, say, somebody said something racist or something, and they thought they were going to might get attacked by the public if it went public.
Yeah.
One would question that it probably should be something that is public or should not be. I don't know.
I don't know. I mean,
it gets a bit.
Should we be dealing with something? I mean, I'm not quite sure when it gets to that. I mean, when it gets to that seriousness, where there's, you know, racism or any sort of ism against any individual, you're in the realms of the law, then, aren't you? To be quite honest with you,
I'm kind of wondering where we draw the lines.
I don't know how we would deal with that. I mean, say, I would assume that if we've got a complaint of racism, that, well, just for a matter of fact, somebody believe the law's been broken. I mean, what would you do with that, Andrew?
Can I answer that to give you two specific examples of cases that we've been involved in? One of which, you know, again, this is, I'm not involved, etc., but one of which involved a councillor making inappropriate comments to a 12-year-old schoolgirl during a school visit. Now, that was very clearly decided that was going to be heard in private session, not least because the 12-year-old girl was there as a witness and there were clear safeguarding issues, etc. But at the end of the process, a summary was still published to say he had been found in breach of having made inappropriate comments. And the second one, which we've just dealt with, which did involve extreme racist comments about travellers in relation to a planning application for a travelling site, we made that became very clear when we discussed this with the monitoring officer. It was going to go to a hearing, it would be held in public, and the member resigned before it came to the hearing because they didn't want those matters made public, but we think that was probably a good outcome.
Okay, just covering on Sally comments, you know, the innocence appearing in front of the public, all of a sudden it's in the public domain and everybody, you know, I don't like private sessions. I like public sessions, but I can see what Sally's saying. with regards to that, because as soon as how many, well, we all know this, and you get charged with something or you end up in court, you're guilty, aren't you? I mean, so that's how the press tend to treat it. I mean, and I'm not quite sure whether we can avoid that, but I do agree with what Sally's saying. All of a sudden, something that was private until such time that the breach has been proven, or we believe there is a breach, and he's been found in breach of the rules. That in the past, that person would have been he would have been anonymous, but now we're saying that person is in the public domain. That's quite a big change. The other question, I do have a question about that as well. If we have a formal hearing and it's in public, one thing I couldn't agree to is that the judgment will be made at that formal hearing, because I think much like as a High Court judge would at a bench with 2 or 3 people, they would go away, they'd have a couple of weeks or a couple of days to think about it, and then they'd come back with their judgment. I think having the members of the panel making that decision in public wouldn't be very healthy. I don't know if anybody agrees with me.
We would expect the panel to retire to consider their verdict in effect. And again, the Local Government Association sets out a process for doing that. We certainly wouldn't expect you to have your deliberations in public.
Right. Because there may be some questions that somebody at that want to ask, and those sorts of questions should be asked in private.
Yeah.
Does everybody agree with that? Yes.
I think the example I'm thinking of recently was the off licence who got done for selling alcohol to kids. It was a publicly viewable hearing, but the decisions were made afterwards in private. And I think that's probably an acceptable way of doing it.
Yeah, I think so, because you wouldn't want to be on the panel making a judgment there if you weren't 100%, and you might feel a bit difficult asking a question in that arena, because we all think we're silly sometimes. Yes, Sally.
What is the purpose of having the hearing in public at the time of the hearing versus having it recorded, and the recording being made public only if the person being complained about is found to be in breach?
Good point.
I think there are 2 things to that. I think, first of all, the law requires you to hold it in public, as with any committee. So you could say the same about why can't you record your planning committee and only broadcast it later, because it is about, essentially, the law says committees must meet in public unless there's a specific legal reason not to do so. And secondly, I do think that there's lots of information commissioner cases around at what stage does a case become public, as it were, and the presumption the information commissioner has always worked when they've received FOI requests, etc., for information, is that the earlier in the process, the more the subject member has the right to confidentiality. So if Andrew's just considering an initial complaint and finds there's no case to answer, it doesn't need investigating, then there is an expectation of privacy on the subject member there. The more it gets into the process, the more public money has been spent upon it, the more there's been a final report produced, the more there's been a recommendation that's breach of the code of conduct, the more the information commissioner has said that those matters are certainly FOIable and should be seen in public.
Yeah, Sally,
that actually really makes a lot of sense. So as a follow-up, could we make the suggestion, or could the suggestion be that as part of the process, it's made very clear that if you decide to go to a formal hearing, or if the process up to this point has resulted in that being the outcome, that at that point, it will be made public what the nature of the claim is, or the complaint is, and against whom. Because both complainant and complainee, a complained about person should be aware of that up front.
Yeah.
Thank you. That makes sense. Thank you for the clarification.
Prue.
I'm just going to ask a question about public access. So is there an obligation to provide a recording, to have stream it or record it and have that available? Or is it just purely that the public is allowed to attend on the day? And the other part of it is there are rules, aren't there, about allowing members of the public to tweet and film things at meetings. Do those apply to hearings as well?
Yes, they do. They apply to hearings as they apply to all committees, because a standards committee hearing is just what's called an ordinary committee of the council. So yes, those rules were applied to them, and I have certainly sat and watched hearings being tweeted live by journalists. I can't answer the question about whether you need to film it as well, because I've lost track of where the rules are now around virtual meetings, etc. But certainly a public meeting means the public has to attend. But Andrew may be better placed to know whether you actually have to film meetings these days.
Yeah, I mean, just sort of there's a number of things from this sort of conversation, not least the guidance that the LGA has recently sort of published in this area, but and I'd need to look at that specific point, Paul, in terms of filming of the meetings or streaming of the meetings. I think what I would say is back to the point that I made earlier about we rarely do have standards panels. So this isn't an event that happens every day of the week or every week or every month. But it's clear from Paul's report to us that it is something that we need to pay attention to. We do need to correct and make clear for the future.
I mean, I think my view, for what that's worth, I don't think it should be recorded. It should be treated in the same way as any court. You can go to a court and watch somebody being tried, but you can't record it. You can't televise it. And I think that's probably not a bad thing in this case.
Just sort of have we have to obey the law. So if the law says we have to do something, we'll have to do it, and that's all we can do, isn't it? So in a way, while I share your concerns about recording things, actually, if the public are allowed to tweet things and otherwise they can use that to misrepresent what's happening. So actually, if you have a full recording of it, you can actually use that to disabuse people of things that they've got wrong by having somebody mischievously misrepresenting what is occurring at the meeting. So there's upsides and downsides, but as I say, we have to obey the law. So Andrew will tell us what the law is, and then that's what we'll have to do.
What are the rules in the law about recording meetings such as these private meetings? It's quite an important one.
Okay, I'll take that away, Chairman.
Okay, the question you have to ask as well is if it went to, you see, you get some difficult ground, because if you have your formal hearing and the decisions that you're not in breach, what happens to the recording then? Is the recording removed and destroyed, or does it stay as part of the council's record? I don't know. I mean, they're all the sorts of questions that really need to be thought about. It's easy to say, make it a public meeting, but there are things that need to be considered around that. Maybe I'm making too much of a meal of it, but it's quite a big change to invite the public into the
it needs, whatever we do has to be compliant with the law, which I think we're not quite yet. So we need to do it.
And just to add to that the law doesn't distinguish between a standards committee hearing panel and any other committee meeting. So whatever you do for other committee meetings is the law that you have to do for a standards committee hearing.
Okay, right, that's the case. Yes, Carol.
Can I just quickly ask about how you're going to advertise to the public? Will that be on the webpage, or will you put it in newspapers, a public hearing?
Well, we only publicise it in the way that we publicise all council meetings at the moment. So it would be through the website, just in those normal ways. We wouldn't have anything different to what we would normally do, as Paul says, for any other committee of the council.
Okay. All right. Is there any other further changes you want to talk about, Andrew?
I think that's it, and just that final point about politically balanced panel, which I think is, as I say, just regularising the custom and practice that we've had anyway.
Sorry, Imogen.
With the panel, I mean, if it's a town and parish one, I gather they've got to have one town and parish councillor on it, or what's the balance of town and parish council? Or are they all being judged by borough councillor?
No, there'd be one town or parish councillor as well.
I find that a bit, for town and parish councillors, I find that a bit, to be, obviously they've largely been judged by borough councillors. I find that a bit out of sorts, really.
Again, sadly, that's the law. There used to be, prior to the Localism Act, there used to be town and parish council representatives on standards committees that had voting rights, but they were removed by the Localism Act. So now the only people who can vote at a standards committee hearing are the borough councillors.
So the parish, town and parish rep that's on there has to be one of the standards committee reps on the thing. It can't be just be any, because I know Sally's an independent. I'm not sure about Roy, but if you've got somebody from a particular political party, because we've got political towns and parishes and independent. Yes, Roy's a member of the Labour Party. That's what I thought. Does that count towards the political proportionality of the committee, or is it just the?
Well, they can't vote.
They can't vote. So it's just yeah.
I'm not saying the only important. What I'm saying is the people who make the decision, the people who make the vote, they need to be proportional.
Okay.
No, it's the rules. I mean, I wouldn't have it like this anyway, but that's what the rules are. Okay, has anybody got anything else to say? Are we happy that this goes forward?
Thank you for a lovely report. I think it's
Thank you. Yes, and we'll pick up some of the technical points with Andrew later, I guess.
Yeah, we just need to make sure that we are clear on those things, especially around adjourning and the judgment coming out later. You know, it's a bit like going to a fight and not knowing the result, isn't it? But I think it's quite important that we give that there is a period of time that people can step out the room and actually discuss what's been presented to them. Yeah. Okay. All right. So are we happy that this goes forward as it is with the caveats that we've been talking about? Okay. And okay then, Andrew, well, it looks like you've done your job here. And thank you very much, Paul. It's been really helpful.
Thank you. And good luck.
Thank you very much.
I shall leave you in peace now. Thank you.
Thank you. Bye-bye. Okay, I got so excited, I forgot we were. Okay. Right, I think it's you again, isn't it, Andrew? Now the update of
it is, Chairman. So this is the normal update that you're used to receiving as a committee. So the report is just to note. What I would say is that I would hope that the recommendations that you've just agreed in the previous report will at least in part help us to get on top in terms of the timeliness of dealing with these complaints. As you'll see from the report, we've made some progress since the last report to you in July, but we've still got some way to go. We have had since the July meeting 4 new complaints that have come in. We've dealt with some of the more historic complaints that you saw back in July, but there were 3 complaints that I was hoping to give you a verbal update on tonight, and I'm afraid I'm not able to do at this evening's meeting, but I'm hopeful that I can get the 21st of June, 22nd of June and 16th of September complaints addressed within the next couple of weeks, certainly by the end of this month. In terms of in terms of the sort of key issues that are coming out of the complaints from my point of view, there's a number of things I'd like to say, and I think that this, with your permission, Chair, and with the committee's views, what I'd suggest is that on the back of this item, every time that you consider it, that through me, Chair, you or I write to all councillors in terms of sort of the key themes, key things that councillors need to pay attention to. So, for example, this time, it's a reminder around confidentiality of information. It's a reminder around conduct in council meetings, and it's guidance and a reminder in terms of councillors' communications with the media, and what is appropriate and what might not be appropriate with regard to that. So this isn't because we've had findings of breaches, but it's just indicative of the trends and patterns that we've experienced over the more recent months. So what I was planning to do is have a communication for councillors within the next week coming out of this evening's meeting. What I also wanted to say, Chairman, was that I'm meeting with the clerks of the towns and parishes next week, and that the prime purpose for that is to talk to them about the LGA Model Code of Conduct that this council adopted in July, and to advise and support the towns and parishes in terms of their adoption of either the model code or something similar, but also to be that conduit with the clerks in terms of the broader findings coming out of Code of Conduct complaints, so that we make a stronger, or I make a stronger connection with the clerks. I know we've got councillor town and parish representation on this committee, but that's one of the particular things that I'd like to take forward from this meeting onwards with regard to towns and parishes. I'll stop there at that point, Chair, but happy to take any questions or any points that members have got around anything in that update report.
Sally.
I'm really glad to hear that you've got a meeting scheduled with towns and parishes next week, because I was actually asked if I could ask at this meeting about what the plan was, because it's October and I don't, and certainly the councils that I'm involved with, they weren't aware that this had been adopted, or wondering what the plan was for rolling it out to the towns and parishes. Could you just tell me a little bit what the plan is and why it's taken 3 months to get to telling them about it?
Well, the plan is to brief the clerks in the first instance. I think it's not the case that maybe not all the clerks, but certainly some of the clerks were aware of the LGA's new model code that came out at last December, January time. Ultimately, it will be a decision for the town and parish councils themselves as to whether or not they wish to adopt the same code of conduct that the borough council has adopted, whether they wish to retain what they've currently got. It is a decision for each of those bodies to make for themselves. But it's a fair point about making sure that not just in the aspect of standards, but in the aspect of all the council's connections with towns and parishes, that we're looking to strengthen that relationship. And as I say, it's something that I recognise that we need to bolster. So I'll be picking that point up, but also the points that we've discussed in the first item tonight as well, in terms of the process for handling code of conduct complaints as well, particularly as they pertain to parish and towns.
Yes, Sally.
Just further to that, obviously what we recommended to the council here was a very slightly amended code of conduct. Given that we are the standards hearing panel, etc., for complaints made against codes of conduct, there are, I think, a majority of our local councils follow the borough code of conduct. So could it could we make a point of letting them know when there are updates and specifically what those updates are? Because you're right, they were aware that there were national guidelines published, but they weren't aware of the changes that had been adopted when they were adopted. Thank you.
Yeah, like I say, it'd be my proposal here on in that after every standards committee or around that same time that there's an explicit briefing between myself and all the clerks to pick up what's coming from the Borough Standards Committee.
That's great, thank you.
Okay, thank you. So, Imogen.
Really, my point is to Sally, in that certainly I know from Wokingham Town Council that our code of conduct is quite different from the borough code of conduct. They're not the same.
My induction, Jan, literally said this is based on the Woking Borough Code of Conduct. I think it was at the time, but obviously it's changed drastically because if nothing else, it's no longer in third person, it's now in first person. So it looks very different.
The Nolan principles are in place everywhere, but our town council's code of conduct is, I think, more stringent than the borough one.
Does that cause any conflict if we have a situation where they don't follow our code of conduct? I mean, if we're the adjudicators at any, I mean, how does that work if they've got different rules?
I think in my experience, Chair, that whilst there might be some minor differences between the Borough Council's code and some of the towns and parishes, they are really minor things. The key principles are the same, and the key aspects of behaviour and the key aspects in terms of declaration and registration of interests are the same. So it's only minor differences.
Okay, but if there was, we would have to clearly know, anybody who was sitting on that panel would have to clearly know what they breached. Okay, if it was different to, even if it's just a minor difference, it can make all the difference. So I think that that's really important. Somehow that needs to get written into to the standards system.
Yes, I will take that action away, Chair, but just to reassure members that if a complaint is from about a town or parish councillor, then my first reference point is that town or parish council's own code of conduct. So that's the starting point that I would always use for any town or parish complaint.
Okay, that's fine. Okay, any more questions for Andrew? No. Good, Sally.
Sorry, there's another one. You talked about sending reminder out about council behaviour. A piece of feedback that I had the other day was that the code of conduct, could it perhaps include some recommended expected conduct for virtual meetings, given that there are now potentially the potential future for hybrid meetings, but also obviously there's no guarantee there won't be another pandemic.
There's a bit of a crossover there, isn't there, between our constitution and the standards, because they're obviously where the constitution is weak is it was never written with a view to dealing with hybrid or meetings which are virtual meetings. Well, that's it. Yeah, I mean, so there is a need to update that at some stage. I don't know whether or not, but the whole thing around social media as well. I mean, as a council, we need to take, and I don't want to get involved in it because I don't want to do it. But there are changes that we need to recognise in our constitution as well as in the standards with regards to this.
Yes, I mean, you do have guidance, Chairman, at the moment around social media, but I think this is a constant sort of reminder to councillors as to what's in the code and different aspects and the things that are particularly topical. Some of those things that I've talked about this evening. But Sally's point, I'll certainly take that away and think about how we can deal with sort of getting good, clear guidance out around virtual or hybrid meetings as well. We do that, but in a perhaps a less formal way, sort of meeting by meeting.
The other thing that we do, the other thing we need to be very clear about, this will no doubt ring bells with the media, and we need to be very clear what we're doing and why we're doing it. It's not because we've got more naughty councils, it's just that what we're doing is we're bringing ourselves up to date for the latest stuff. I mean, it's not a judgment on the people in the council. I think that's really important that goes out, and it makes that very clear that the rules have changed, and because of the rules have changed, we're evolving what we do ourselves so it fits within the rules. Everybody happy with that comment? Yeah, okay. I think that's about it, isn't it? Thank you very much, Andrew. Okay. There is nothing else that I've got. Is anybody else in the room got anything that they want to bring up, speak about, or? Okay, well, thank you very much for attending. I'm Prue Artelke,